Welcome to the deep dive. Today, we're diving deep into a really crucial area of EU law, the free movement of capital.
Absolutely essential stuff.
And this discussion, just so you know, is based on materials made available to students by the University of London. We want to give them full credit.
Great materials, really helpful.
And please remember, this is purely for educational purposes. It's brought to you by Sinorbit Academy, Sri Lanka.
And from both of us, seriously, the very best of luck with your exams. We know this stuff can be challenging.
Definitely. So free movement of capital, it sounds complex, maybe a bit dry.
It can seem that way, lots of articles, cases. But our goal today is really to boil it down, find the core concepts, the key cases you need to know, and those important distinctions.
Right, make it stick, help you actually study it effectively, and hopefully feel more confident for those exams.
Exactly, not just a data dump.
Okay, so let's start at the beginning then. Where did this whole idea come from in the EU?
Well, way back in the Treaty of Rome, the initial idea was quite cautious. It talked about freeing capital movement, but only to the extent necessary for the common market.
Only to the extent necessary, so not wide open from the start.
Not at all. And the Casati case, that C-2380, back in 81, really underlined this. The court basically said, look, capital isn't quite like goods or people. Letting it flow completely freely could mess with a country's own economic policy.
Okay, so there was this immediate tension, wasn't there? The single market idea versus national economic control.
Precisely. That's the core tension you see evolving. But over time, people realized these restrictions were actually holding back the single market itself.
So what changed things?
A big push came with stage one of the Economic and Monetary Union, the EMU. That was a real turning point, a commitment to proper free movement of capital.
And was there a specific law?
Yes. Council Directive 88361, that was key. Article 1.1 explicitly banned all restrictions on capital movement between member states.
All of them?
All restrictions. Okay, that's a definite shift. Huge shift. And this full liberalization was then locked into the Maastricht Treaty. So you see this clear path from limited necessity to a fundamental freedom.
And it wasn't just about the capital itself, right? Payments had to be free, too.
Absolutely connected. You can't really move capital without making payments. The old Article 1061 EEC touched on this, ensuring payments were possible.
Right.
Now, Article 63(2) TFEU makes it very clear. No restrictions on payments between member states or even with third countries.
Capital and payments, two sides of the same coin, basically.
You could say that, yeah. They work together.
Okay, so that's the history. Now, Article 63 TFEU is the main one today, right? What exactly counts as capital movement under that article? Is it just sending money across borders?
Article 63 is the bedrock, yeah. It lays down the basic rule, no restrictions. And Article 64 extends this, importantly, to dealings with third countries, too.
But the definition?
Funny enough, the treaty itself doesn't define capital movement. It's a bit vague there. So the court, in Trummer and Mayer, that's C-2290 from 99, said, okay, let's look at the list, the nomenclature, attached to that 1988 directive, Directive 88361.
So Trummer and Mayer points us to the directives list for the definition. That's useful for studying.
Exactly. That's the connection to remember, Trummer and Mayer and the directives list.
So what's on that list? Give us some concrete examples. What kind of transactions are we actually talking about?
Right. So based on that list and the cases that followed, it includes things like mortgages. The Westdeutsche Landesbank case, C46498, dealt with creating a mortgage in another currency. That count.
Really? Mortgages. What else?
Direct investment. A company from one member state setting up a subsidiary or buying property in another. The Commission v. Portugal, Golden Share case, C36798, is a big one there.
Golden shares. We'll probably come back to those.
We probably will. Then you have financial investments, buying shares, bonds, that kind of thing, in other EU countries. Commission v. Netherlands, C28204, touches on this.
Okay. Loans?
Yep. Granting loans and credits across borders. The Fidium Finance AG case, C45204, confirmed that.
And you mentioned gifts earlier. That seems surprising.
It does, doesn't it? But yes, even things like cash gifts or inheritances moving between member states fall under capital movement. The Hein-Perchik case, C31807, established that for gifts. It shows how broad it is.
Really broad. Anything else beyond that directive list?
Yeah, the court hasn't stopped there. Take the Verkooijen case, C3598. That confirmed that receiving dividends from a company based in another EU member state is also covered by Article 63. So the list isn't exhaustive. Remember, Verkooijen for dividends.
Okay, so Article 63 is this powerful, broad prohibition. Can ordinary people or businesses actually rely on it directly in their own country's courts if they think a national rule is blocking their capital movement?
Ah, direct effect. Yes, this is a really critical point for exams. Remember Casati, that early case.
The cautious one, yeah.
Back then, the court said no. Article 63 did not have direct effect. You couldn't just walk into court and rely on it.
But that changed.
It did. Big time. In the San Stellara cases, C-16394 and others in 1995, the court completely reversed its position. It said Article 63 lays down a clear, unconditional prohibition. It doesn't need any extra laws from member states to work.
So individuals can use it now.
Yes. Individuals and companies can directly invoke Article 63 in national courts to challenge restrictive national rules. And this is also crucial. This direct effect also applies to capital movements involving third countries, countries outside the EU.
Okay, so that's a key development. Casati, no direct effect. San Stellara, yes. Direct effect even for third countries. Got it.
That's the evolution to remember.
So this prohibition in Article 63, it covers all restrictions. Does that just mean stopping member states discriminating against foreigners, treating their own nationals better?
No, it goes much, much further than just discrimination. That's a really important point. Of course, it covers direct discrimination, treating someone differently purely based on their nationality or where the capital comes from.
Like the Austrian planning permission case?
Exactly, like Comley, C30297. Austria exempted only its own nationals from needing planning permission for certain land deals. Clear direct discrimination. Or the Albor case, similar issue.
Okay.
And also rules limiting share purchases by foreign investors in privatized companies, like in Commission v. Portugal with the Golding shares. That's direct discrimination too.
So Conley and Commission v. Portugal for direct discrimination, but you said it goes further.
Yes. It also covers indirect discrimination. These are rules that look neutral on the surface, maybe apply to everyone, but in practice, they put cross-border capital movements at a disadvantage.
Okay. Indirect discrimination.
And even beyond that, it covers measures that aren't discriminatory at all, directly or indirectly, but simply act as a barrier or a deterrent. They just make it harder or less attractive to move capital across borders. So any measure that hinders market access.
Wow. So 3 levels. Direct discrimination, indirect discrimination, and just plain restrictions on access.
That's a good way to think about it.
Can you give examples of those non-discriminatory restrictions? Things that just get in the way?
Sure. Requiring prior authorization before someone from another member state can invest. Even if everyone needs it, it can deter foreign investment. That was the issue in the Église de Scientologie de Paris case, C5499.
Prior authorization. Yeah, that sounds like a hurdle.
Definitely. Or imposing a stamp duty specifically on loans taken out from lenders in other member states, like in the Sandoz GmbH case, C43997. Makes foreign loans more expensive, less attractive. That's a restriction.
Okay, Sandoz for stamp duty. What about taxes?
Taxes are a big area. A higher inheritance tax on property inherited from another member state, compared to domestic property that was initially seen as a restriction in Jaeger C25606.
Initially.
Well, the court's view on inheritance tax details evolved a bit in later cases like Eckelkamp and von Hilton von der Heyden. But the principle remains tax rules making cross-border activity less favorable can be restrictions.
So Église de Scientology, Sandoz, Jaeger, these show different kinds of hurdles.
Right. Other examples. Higher capital gains tax just for non-residents, like in Holman, C443006. That clearly discourages non-resident investment.
Makes sense.
And those golden shares, again, like in Commission v. UK, C9801. Giving the government special voting rights in privatized companies, even if it applies to any potential buyer, deters investors, especially foreign ones. So it restricts capital movement.
So even if the rule isn't about nationality, if it deters investment, it's a restriction.
Precisely. Or less favorable tax treatment for dividends paid to companies in other member states, as in Amerda SGPS C37905. The key takeaway is, Article 63's prohibition is incredibly broad. Any measure hindering access or making cross-border capital flow less appealing is potentially caught.
Okay, that scope is really wide. Now, you mentioned Article 64 extends this to third countries outside the EU. How freely does capital move in and out of the EU then?
It's unique, actually. Capital is the only one of the 4 freedoms that explicitly applies beyond the EU's internal market, thanks to Article 64.
But are there catches?
Oh, yes. It's not completely unlimited. There are exceptions. Member states can take safeguarding measures in exceptional circumstances. Critically, they could keep restrictions on capital movements to or from third countries if those restrictions already existed before the end of 1993, a kind of grandfathering clause.
Ah, pre-1994 rules can stay.
They can, yes, and new restrictions are possible, but only under very specific conditions laid down in the treaty. So it's broader than within the EU, but still subject to controls.
What about tax differences, like taxing dividends from a U.S. company differently than from a French one?
That came up in Skedeverket VA, C10105. Sweden taxed dividends from non-EEA companies less favorably than those from within the EEA, unless there was a tax information exchange agreement.
And the court said,
A court said, yes, that's a restriction on capital movement with third countries. However, and this is the key point, they accepted Sweden's justification. They argued it was necessary for effective fiscal supervision because getting tax information from outside the EEA could be harder.
so a justification that might work for third countries might not work within the EU.
Exactly. That's the crucial takeaway from Skedeverket VA. The standard for justifying restrictions might be slightly different, arguably lower, when dealing with third countries compared to intra-EU movements, especially concerning things like tax supervision.
Okay, so Article 63 is broad, applies within the EU and to third countries, but it's not absolute. There have to be exceptions, ways for member states to justify restrictions sometimes.
Derogations, right?
Yep.
Correct. Derogations are the exceptions. Articles 65, 75, and 215 TFUU are where you find these. Broadly, there are two types of justification.
Here, types.
First, there are justifications based on what the court calls overriding reasons in the public interest. These aren't explicitly listed in the treaty for capital, but the court recognizes them, similar to other freedoms. Think public good type arguments.
But with conditions.
Always. The big condition is proportionality. Any measure taken must be suitable for achieving the objective, and it mustn't go further than necessary to achieve it. Suitability and necessity, the two prongs of proportionality. Very important concept.
What kind of public interest reasons have worked?
We've seen a few. Fiscal supervision, like in Skedeverket, ensuring a smooth transition between legal systems, as in Stiko Industry Montage, C37707, guaranteeing essential public services of general interest, like the Post Office and Commission v. Netherlands.
Okay.
Maintaining a permanent population in certain areas that was accepted in principle in Conley, and safeguarding essential supplies, oil, telecoms, electricity, like in Commission v. Spain, C4637.
So a range of legitimate concerns. But they can't just say it's good for our economy, right?
Absolutely not. Purely economic justifications trying to protect your own industries or manage your budget deficit that way are a big no-no. The court has consistently rejected those. Think Mannanen, C31902, or Verkoeien on that.
No economic protectionism allowed.
Basically, no. And even if the reason itself is legitimate, like maintaining population in Conley, the specific measure has to be proportionate. Remember, in Conley, prior authorization was too much. A simple declaration would have been enough. Or in Commission v. Netherlands, the golden share went too far. Always check proportionality.
Okay, so public interest justifications judged by the court must be proportionate. What's the other type of derogation?
The second type comes directly from the treaty itself, mainly in Article 65. These are specific grounds listed in the text.
What does Article 65 allow?
Article 65(1) allows member states to have tax laws that differentiate between taxpayers based on where they live, residents, or where their capital is invested.
Okay, tax differences allowed there.
And Article 65(1)(b) allows measures needed to prevent infringements of national law, especially tax law, and prudential supervision of banks and financial institutions. It also covers declaration procedures for monitoring capital flows and measures justified on grounds of public policy or public security.
Public policy, public security. Those sound quite broad.
They do, but we'll see they're interpreted narrowly.
Okay.
And you also have Articles 75 and 215, which allow for financial sanctions, often related to combating terrorism. So Article 65 gives specific headings for potential justifications.
But are these Article 65 justifications automatic? If it's about tax or public security, is the restriction automatically okay?
Definitely not. The Scientology case is crucial here. It stressed that all these Article 65 derogations must be interpreted strictly. Member states can't just use them as an excuse for purely economic aims. And, critically, they are always subject to the principle of proportionality and the conditions in Article 65(3).
Article 65(3), what's that?
Article 65(3) says that even measures allowed under Article 65(1) must not be a means of arbitrary discrimination or a disguised restriction on the free movement of capital. It's a safety net.
So even if it fits under a heading like tax differentiation, it can still be struck down if it's arbitrary or a hidden restriction.
Precisely. Strict interpretation, No purely economic aims, proportionality, and no arbitrary discrimination or disguise restrictions under 65.3. Those are the limits.
Okay, let's dig into 65.1, the tax differentiation one. It allows different rules for residents and non-residents, but you said it's limited by 65.3. How does that work?
Right. So Article 65.1a acknowledges that tax systems often treat residents and non-residents differently. But as the Lens case, C3-15002, showed, it's not a blank check. You can't just have any difference. It always comes back to that Article 65.3 check. Is the difference arbitrary discrimination or a disguised restriction?
How do you tell if a tax difference is arbitrary? That seems subjective.
The court developed a specific two-step test for this, which you really need to know for exams. It came out clearly in cases like Verkooijen and Menenen.
Okay, the two-step test. What is it?
Step 1. Are the situations objectively comparable? Is the non-resident taxpayer in a situation that's basically similar to the resident taxpayer with regard to the specific tax rule in question?
So compare their situations first.
Yes. If their situations are not comparable, then different treatment might be okay because they're not in the same boat to begin with.
But if they are comparable,
Then you move to step 2. If there are incomparable situations, is the difference in treatment justified by an overriding reason in the general interest? And is the measure proportionate to achieving that justification?
so comparability first, then justification and proportionality.
Exactly. If the situations are comparable, but the difference isn't justified or isn't proportionate, then it's likely arbitrary discrimination or disguised restriction, and it breaches Article 63, even though it looks like it fits under 65.
Can we have examples of comparable versus non-comparable situations in tax cases?
Sure, comparable situations. In Persia, the court said charities inside the country and charities in other EU countries were comparable when it came to tax deductions for donations. In Holman, residents and non-residents were comparable regarding capital gains tax on property. In Boanich, resident and non-resident shareholders were comparable regarding tax on share repurchases.
Okay, those were comparable. When were they not?
Blanchard is a good example of non-comparable. Tax credits linked to national insurance contributions. The court said people insured under the national system were just not in a comparable situation to those who weren't. The difference in treatment stemmed directly from that objective difference.
Right, that makes sense. Comparability depends on the specific issue.
It does.
And if they are comparable, what about step 2? The justifications. Have member states succeeded often?
They often struggle at step 2. The court is quite strict. For instance, arguing for fiscal cohesion, needing to balance a tax advantage with a tax burden within the same system, often fails unless there's a very direct link, which the court didn't find in Wiedert and Paulus, C24203.
So fiscal cohesion is a tough sell.
Generally, yes. And just saying it's hard to check taxes across borders isn't usually enough on its own either, as seen in Walter Scoffer, C386804. The court might accept proportionate administrative measures to help with verification, but not outright denial of a benefit just because it's cross-border.
So the justification needs to be strong and directly linked, and the measure proportionate.
That's the essence of it for Article 65.1a.
Okay, now what about the other main part of Article 65, paragraph 1b, preventing infringements of national law, public policy, public security?
Right, 65.1b. This covers measures needed to stop people breaking the law, especially tax laws or rules for supervising banks, prudential supervision. It also allows for declaration procedures, making people declare large sums of money crossing borders, for example.
Is that list exhaustive? Tax, supervision, declarations.
No. The Bordessa case showed it's not. The court has accepted it can cover measures against other serious illegal activities, like money laundering, drug trafficking, terrorism financing.
But still subject to 65.3, no arbitrary discrimination.
Always. And proportionality.
Yeah.
Take preventing tax evasion. The Sandoz case, the stamp duty one we mentioned.
Yeah, on foreign loans.
The court allowed that stamp duty under 65.1b because it was seen as a non-discriminatory measure aimed at preventing tax evasion. It applied regardless of where the loan came from.
But contrast that.
Contrast that sharply with Commission v. Belgium, Eurobond. Belgium completely banned its residents from buying certain foreign securities, arguing it was to stop tax evasion. The court said, whoa, that's totally disproportionate. You can't just assume everyone is evading tax and ban a whole category of investment.
So Sandoz okay, Commission v. Belgium not okay. Proportionality again.
Exactly. A specific measure versus a blanket ban based on suspicion.
And public policy, public security, how narrowly are those interpreted?
Very narrowly. The burden of proof is squarely on the member state. In Scientology, the court hinted that maybe, just maybe, If an organization posed a genuine, serious threat to public order, you might be able to justify different treatment for capital inflows linked to it. But the measure would need to be incredibly precise and targeted, not general. Legal certainty is key.
So, high bar.
Very high. And still needs to be proportionate, as Albor reiterated.
What about the golden share cases here? Didn't they involve public security arguments?
Yes, they did. And they show contrasting results. In Commission v. Belgium, the court actually accepted that a golden share in the energy sector could be justified on public security grounds, ensuring energy supply, but only if the special rights were strictly limited to what was needed to guarantee a minimum supply.
So, potentially justifiable, but only if tightly controlled.
Right. Compare that to Commission v. France. France had a system requiring prior government approval for certain foreign investments, arguing public interest security. The court shot it down. It was too broad, gave the government too much discretion, lacked legal certainty, and was therefore disproportionate.
So again, it's about specific threats and proportionate, clearly defined responses, not broad discretionary powers.
That's the consistent message from the court.
Okay, we've covered Article 65.1 in detail. You mentioned other derogations too. Briefly, what are 65.2, 64, and 66 about?
Quickly, Article 65.2 just clarifies that capital rules don't override legitimate EU-compliant restrictions on the freedom of establishment. But again, subject to 65.3, no arbitrary discrimination. Article 64, we touched on, allows those pre-1994 third country restrictions to continue and sets a goal for liberalization towards third countries. Article 66 is an emergency brake, allows the Council to take temporary safeguarding measures if the EMU runs into severe difficulties. Very exceptional circumstances.
And Skinevriket showed third country restrictions might be easier to justify sometimes.
Yes, that possibility exists, particularly where issues like effective supervision are genuinely different compared to within the EUA.
Right. We've talked a lot about the rules, the articles, the cases. Let's zoom out slightly. How does all this fit into the Economic and Monetary Union, the EMU?
EMU is the bigger project, aiming for much deeper economic integration, coordinating economic and fiscal policies, having a single monetary policy run by the European Central Bank, ECB, and for many countries, the euro.
And free movement of capital was part of that from the start.
Absolutely foundational. Stage 1 of EMU, starting in 1990, was when Directive 88361 came in, mandating the free movement of capital. It also involved closer economic policy coordination and central bank cooperation.
What about stages 2 and 3?
Stage 2 strengthened coordination, set up the forerunner to the ECB. Stage 3 was the big leap, locking exchange rates, launching the euro, and bringing in binding rules on economic policy, especially the famous limits on government debt and deficits.
Those strict conversions criteria countries had to meet.
Exactly. High hurdles covering inflation, exchange rate stability, long-term interest rates, and sustainable government finances. Free capital movement was seen as essential for this whole system to work.
So how does EMU influence capital movement today?
Well, within the euro area especially, you have the ongoing coordination of economic and fiscal policies under things like the Stability and Growth Pact, SGP. The ECB sets monetary policy independently for the whole zone. Articles 120 and 121 TFEU stress that member states' economic policies are a matter of common concern, needing coordination. So while capital is free, its context is this highly coordinated economic environment.
Has the EMU project faced bumps that affected capital, like the debt crisis?
Oh, definitely. The sovereign debt crisis was a massive test. It led to things like the European Financial Stability Facility, EFSF, to bail out countries. And afterwards, there's been a big push for tighter financial regulation, like the Single Supervisory Mechanism, SSM, for banks. These don't stop capital movement, but they add layers of oversight and potentially affect how capital flows, especially in the financial sector.
Okay, this has been incredibly thorough. Thank you. Now, thinking specifically about our listeners studying for exams, what are the absolute must-focus points from all this? How should they structure their revision?
Okay, exam focus. First, understand the story, the evolution. From the limited extent necessary approach in Casati to the full prohibition and direct effect in Sonstolera. That's a key narrative.
History matters.
It does. Second, nail the scope of Article 63. No, it's broad, covers payments too, and extends to third countries, Article 64, although with caveats. Understand how capital movement is defined, referencing Trummer and Mayer and the directives list, but also cases like Verkooyen going beyond it.
Cope and definition. Got it.
Third, the types of restrictions. Be super clear on the difference between direct discrimination, Connolly, Commission v. Portugal, indirect discrimination, and non-discriminatory restrictions hindering market access. Ecclesiastology, Sandus, Holman, Golden Shares. Be ready to spot these in problem questions.
Distinguishing the restrictions.
Yeah.
Crucial.
Fourth, case law. You don't need every detail of every case, but know the key ones we've discussed and the principle each stands for. Cassata Stellera, direct effect. Trummer and Mayer, definition. Conley, direct discrimination. Skadivverket, third country's justification. Verkooy and Meninen, two-step test. Persha-Holman, comparability. Sanders Commission v. Belgium, tax evasion justification. Scientology golden share cases, public policy security. Focus on the court's reasoning. Why was it a restriction? Why was the justification accepted or rejected?
Know the cases and their point. What about the derogations, Article 65?
Structure your thinking there. Distinction 1. Public interest justifications, judge-made proportionality is key, versus treaty-based derogations in Article 65. Distinction 2. Within Article 65, No. 65(1)(a) is about tax differentiation and is governed by that vital two-step test for Verkooy and Meninen, comparability first, then justification proportionality. Know the case examples for comparability. Persha, Holman vs. Blanchard.
The two-step test is critical for tax.
Absolutely. For 65(1)(b), know the grounds, preventing infringements, public policy security. Remember, it's interpreted strictly Scientology, not exhaustive, Bordessa, subject to 65(3). No arbitrary discrimination, disguise, restriction. And proportionality. Sandoz versus Commission v. Belgium, golden share cases.
Structure the derogations, focus on the tests and limits.
Exactly. And finally, have a basic understanding of the EMU stages and aims and how free capital movement was a building block for that whole project. Try to link the concepts. How does direct effect relate to the types of restrictions? How does proportionality apply across different justifications? Making those connections helps understanding.
That's fantastic, really practical advice. So, wrapping up our deep dive, Article 63 imposes a very broad ban on restrictions, covering direct and indirect discrimination and measures hindering access. This extends to third countries via Article 64. Derogations exist, both public interest and treaty-based in Article 65, but they are interpreted strictly and always subject to proportionality and the rule against arbitrary or disguised restrictions. Case law is absolutely key to understanding how these principles work in practice.
Well summarized. And maybe a final thought for students to ponder.
Yeah.
How does this ongoing balancing act between free capital flow and member state sovereignty play out today? Especially with things like digital currencies, sanctions, sustainability goals.
Yeah.
It's a dynamic area, always evolving.
A great point to end on. Thank you so much for that insightful discussion. And thank you, our listeners, for joining this educational deep dive based on University of London materials and brought to you by Sinorbit Academy, Sri Lanka. Once again, we wish you the very best of luck with your exams.